Don, can I check my mic? Is it working? Don, can you hear me?
Sorry, yes, I can hear you very well.
Cool, how are you?
Good day and good afternoon, everybody, and welcome on behalf of the Coalition for an Effective African Court on Human and People's Rights. My name is Kajal Ramjathan Keo. I am a member of the Executive Committee of the Coalition, and I am with the Southern Africa Litigation Center. You will have noted that the Coalition has been inactive for an extended period, but the Executive Committee is actively working with the Secretariat to reinvigorate the Coalition to enable it to perform its coordination and leadership role as in previous years. In order to succeed with this, we do require the support of member organizations and partners, and we look forward to your support. The background to this webinar discussion for this morning is on withdrawals from the African Charter. 4 African states who are parties to the protocol to the African Charter on Human and People's Rights on the establishment of an African court have withdrawn the declaration they made under Article 34.6 of the protocol, which allows the African court to receive cases from individuals and NGOs. These states are Rwanda, Tanzania, Benin, and Cote d'Ivoire. And this leaves only 6 out of 30 state parties that recognize the jurisdiction of the African Court to receive cases from individuals and NGOs. It is significant to note that the government of Tanzania has the highest number of cases filed by individuals and NGOs, as well as judgments issued against it by the African Court. We start off this morning with the keynote address, which is being delivered by Adama Dieng, the United Nations Special Advisor of the Secretary General on the Prevention of Genocide. We are delighted to have Adama joining us this morning. And thereafter, this will be followed by presentations from state representatives. The first session is moderated by Osai Ojiko and Alioni Tiene. Osai is the country director of Amnesty International Nigeria. Alioni Tiene is a former chair of the Senegal Human Rights Commission. And with that welcome, I would like to hand over to our keynote address for this morning. So over to Mr. Adama Dieng.
Hello, I hope you do hear me.
Yes.
Perfect. Well, thank you very much, Madam Moderator. Thank you, dear friends of the African Court and the African Human Rights System. Allow me first and foremost to thank the Coalition for inviting me to not only take part in this important activity, but also and above all, to allow me to kick off the debate on the challenging issue of the withdrawal by a number of African states of the declaration they had made to allow individuals and NGOs to sue them before the African Court. I'm also delighted to be with you today because the Coalition has brought me back to the community to which I belong and which I involuntarily left for almost 2 decades to take responsibilities within the United Nations system. And this return, if I may say so, to my family is happening at the right time, as I have decided to leave soon the United Nations. This is a time where we are rewriting history. This is, in fact, a decision I kept postponing for the last 2.5 years to assist Secretary General Antonio Guterres in the accomplishment of his challenging mandate at a time we are facing retreat in internationalism, at a time we are facing attack on multilateralism. We are, however, living a historical moment, and I can no longer resist to returning back to Africa to share my over 40 years of experience in the field of human rights, democracy, and the rule of law. And this is the time to lend support to African states in their efforts to strengthening their state institutions and ensuring a transparent governance rooted in the respect of human rights and the rule of law. It is first and foremost the time to engage with the human rights movement, to my natural family, the civil society. And of course, I will be more than happy to assist the coalition and other actors to strengthen the African Code, to whose creation I modestly contributed. In doing so, we will allow millions of Africans to continue to believe today more than yesterday in the rule of law and respect for life and human dignity. I would be remiss, the court sitting in Arusha, to not pay tribute to a great son of Africa, to my friend and brother Ahmed Salim, who was truly committed and supported our engagement at that time, which gave birth to the protocol. And I wish him a better health, as I understand he's not feeling well these days. Brothers and sisters, it is always difficult to remind African politicians that the commitment they made to our continental human rights system come with cost, and that states should always take them into account. Because in ratifying the African Charter on Human and People's Rights, through which they agreed to recognize the rights, duties, and freedoms enshrined in the Charter and undertake to adopt legislative or other measures to give effect to them. The history of the African Code confirms this statement by linking the idea of its creation to a commitment to enhancing the human and people's right protection system. When in June 1994, the Assembly of Heads of State and Government of the Organization of African Unity, OAU, directed the Secretary General of the OAU to convene a meeting of government experts to work on a protocol establishing an African Code on Human and People's Rights, it was with the view of enhancing the efficiency of the African Commission on Human and People's Rights. And the protocol confirms this vision by clearly stating that the code was set to complement and reinforce the functions of the African Commission on Human and People's Rights. With this underlying principle, the two institutions, the Commission and the Court, must work in tandem to serve and ensure promotion and protection of human and people's rights for African citizens. The protocol then came into force on the 25th of January 2004 after ratification by 15 states. To date, there are 30 states parties to the African Code Protocol. One of the provisions of the protocol that was the subject of successive negotiation between states was Article 5 on access to the court. It should even be clear that this article was finalized at the last session of the meeting of government experts because states wanted to limit by all means its access to individuals and civil society organizations. However, as with the African Charter, the article was drafted in such a way as to pave the way for two possibilities of access to the court. Today, access to the African Court can be direct or indirect. Entities that have direct access to the African Court are the African Commission, a state party which has lodged complaint to the Commission, a state party against which a complaint had been lodged at the Commission, a state party whose citizen is a victim of a human rights violation, African intergovernmental organizations, individuals or non-governmental organizations with observer status with the African Commission, provided that the state party against which they are lodging their complaint has made a declaration allowing them to do so. In comparison with other regional human rights systems, in particular the Inter-American Human Rights System, which also has a court and a commission, there is no direct access for individuals, groups of persons, or NGOs to the Inter-American Court. Access to the court by individuals and NGOs is done only through the Inter-American Commission and where the country against which the complaint was filed has accepted the jurisdiction either unconditionally or on condition of reciprocity. The European human rights system, on the other hand, allows direct access for individuals and non-governmental organizations to the European Court of Human Rights. This, however, is after the restructuring of the institutional machinery established by the European Convention on Human Rights in order to maintain and improve the efficiency of its protection of human rights and fundamental freedoms in the view to increase the number of applications and the growing membership of the Council of Europe. Prior to the restructuring, individuals and NGOs were denied direct access. The African Commission has created, through its rules of procedures, an indirect access to the court. And this is possible under the following conditions. The country against which the complaint is lodged is a party to the protocol. When the complaint is related to serious or massive human rights violations, a state party has not complied or is unwilling to comply with the recommendation in respect of a communication within a period stated in Rule 112(1). Any complaint if it deems necessary. With regard to the provision that required state parties to deposit a declaration that recognized the jurisdiction of the African Court to receive cases directly from individuals and NGOs with observer status before the African Commission, the practice of African states, with the notable exception of Burkina Faso, has been to delay in depositing the required declaration under Article 34(6) of the African Court Protocol. To date, only 10 out of the 30 state parties have deposited a declaration. And as you reminded us, Madam Moderator, 4 of them have already withdrawn theirs. This means that another 25 member states have not even ratified to date. The practice of withdrawal is not specific to African states, as 2 states parties to the American Convention on Human Rights, namely Trinidad and Tobago and Venezuela, have respectively in 1998 and 2012 presented their instrument of denunciation of the convention to the Secretary General of the Organization of American States, OAS. In Europe also, Russia, the United Kingdom, and Turkey have threatened to withdraw from the European Convention on Human Rights. The very concern of African citizens is to have a continental human rights judicial institution that is established with genuine motives of enhancing promotion and protection of human and people's rights in the continent. But it is not as effective and accessible as it should be, almost 2 decades down the line after its establishment. The complexities of balancing between state sovereignty and the commitments under international law can be understood. However, when the common goal is to work towards the promotion and protection of human and people's rights across the borders of our countries and for the betterment of our own people in any other form, we must accept to make some sacrifices. This is why the principle of good faith, or pacta sunt servanda, comes into play, as stipulated under Article 26 of the Vienna Convention on the Law of Treaties, which states that every treaty is binding upon the parties to it and must be performed by them in good faith. Let us examine the justification put forward by the states that withdrew their declarations as to whether they are adequate to justify their decisions. According to the government of Rwanda, it had never envisaged in making its declaration that a genocide convict who is fugitive from justice could secure a right to be heard by the African court. The Tanzanian government's argument is more concise as it justifies its decision by the fact that the declaration has been implemented contrary to the reservations submitted by the United Republic of Tanzania when making its declaration. The Beninese argument is more straightforward as it considers withdrawing its declaration on the grounds of not wanting the court to, and I quote it in French, s'immiscer dans les domaines qui n'ont pas été attribués à sa compétence et dont il résulte une grave perturbation de l'ordre juridique interne et l'instauration d'une véritable insécurité juridique en tout point préjudiciable à la nécessaire attractivité économique des États partis. So, according to the government of Benin, the court really interfered in its internal affairs by, and I French again, ordonné le 14 février 2020 la suspension de l'exécution d'un jugement d'adjudication rendu par le tribunal de commerce de Cotonou dans une affaire opposant des personnes privées, opérateurs économiques, dans le cadre d'une procédure ordinaire de recouvrement de créances par voie de saisie immobilière en application des dispositions du traité de l'Organisation pour l'harmonisation en Afrique du droit des affaires, le traité de l'OHADA, alors même que le débiteur a pu exercer les recours ouverts devant les juridictions nationales et communautaires que sont la Cour d'appel de Cotonou et la Cour commune de justice et d'arbitrage. End of quote. By ratifying the African Court Protocol, state parties have agreed and consented to give in to the authority and jurisdiction of the African Court and to be bound by its decisions. This is articulated under Article 30 of the African Court Protocol, which states that, and quote, the state parties to the present protocol undertake to comply with the judgment in any case to which they are parties within the time stipulated by the court and to guarantee its execution. Having established the ground for our discussion, it is important that while we are deliberating, we reflect critically on our current system and ask ourselves these questions. How does the requirement to deposit the declaration impact the protection of human and people's rights in Africa? Why are some state parties reluctant to deposit the declaration, and what prompted other state parties that have deposited the declaration to do so? Are the reasons leading to the withdrawal of a declaration more important than the protection of human life and dignity? How do we persuade states that have decided not to accept complaints against them before the court to reconsider their position? What role can the African Commission, the African Union, national human rights institutions, civil societies, the academia, and others can play to enhance access to and the effectiveness of the African Court and the African human rights system? I thank you, Madam Moderator, brothers and sisters. Let's hope that we will really make a big difference the years to come for the respect of human rights and human dignity in our continent. Over to you.
Thank you very much, Mr. Madieng, for your opening statement. We would now very much like to proceed to the next session, which is to get responses from our guests. I would like some support from the Secretariat to confirm if we have the representatives of State Party on this conversation, on this call at this point in time. State representative from Benin and from Côte d'Ivoire. Is there confirmation that they're on this call at this time? It appears we might not have them on the call at the moment. So to save time, can I also check if we have the representative from Burkina Faso or Tunisia on this call at this time? So yes, please, if we have any state representative on this call, can you indicate by typing in the chat box so we can give you the floor? It is important that this session is one where we can interact as civil society, as representatives of government, national human rights institutions present, in order to have frank conversation, discussion on the Article 34.6 Declaration of the African Court, or the African Court Protocol. Okay, so I understand that at this point in time, we do not have state representatives yet. So in order to move forward with the conversation, I think we can move on the agenda if that's all right with everyone. And when they do come, we would be happy to give them the floor. So essentially, it would have been really good to get some feedback, especially arising from Mr. Damadieng's keynote speech in terms of where do state parties come from. But nevertheless, I would like to call on Dr. Robert Eno, who is a registrar at the African Court, for his reaction in terms of what can he contribute to this conversation. The court has been active for a number of years, cases have been progressing, and then suddenly we are faced now with these withdrawals from various states. So how does this impact also on the court and the court's effectiveness and the work that the court has done so far? So Dr. Robert Eno, I would like to give you the floor. Thank you.
Thank you, Ose. Nice to see you again after a very long
Same here.
Long while. Thank you for the keynote address. I'm going to, I had wanted to talk on the reasons why the 4 states withdrew, but this has been properly articulated by Adam Madieng. Let me say statement on the 4th of May, raising concern about the withdrawal, but also reiterating the fact that it is going to do its work without fear or favor. The withdrawal is come after, of course, and colleagues would note that when Rwanda, the court issuement principles, the first one was that, yes, sovereign states have the right to withdraw either a declaration or from a treaty. It is their sovereign right. And the second principle was that although they have that right to withdraw, that right is not absolute. They need, because by depositing the declaration, they have already engaged other entities that derive rights by virtue of the deposit of that declaration. And as such, individuals who had already engaged rights as a result of that declaration have to be given notice. And the court drew inspiration from other international courts and the Vienna Convention.
Yes, we can see. It appears that Dr. Eno is having some connections. The speech comes in and goes out. Dr. Eno, can you hear us? Can you hear me?
Can you hear me now?
Yes, we can hear you, but sometimes we lose your voice.
Sorry.
Okay, but it's clear now, so please proceed. Thank you.
Is that withdrawal does, yeah, a withdrawal ongoing at the court. And within the 1 year period, the court can receive cases against that state that has withdrawn. So those were the principles established by the court in the Ingabire matter with respect to the Rwanda withdrawal. And those are the same principles that the court has adopted with respect to the subsequent withdrawals. What has the court done to ensure that this Article 34.6 is repealed? In 2009, when the court was invited by the AU to make some human rights, the court made a submission, opposed the repeal of Article 34.6. The new protocol, the Malabo protocol, with Article 34.6 should not feature. Unfortunately, that did not happen. In 2015, in submitting its activity report, the court again made a submission on the repeal of Article 34.6. But that again was rejected. In in 20 and the ambassadors actually told the court that they don't want to decided that they want Article 34.6 to be in the protocol. So since then, the court has not attempted to request for a repeal of Article 34.6, decided already done so. To call and deposit the.
Yes, it's challenging at the moment, Dr. Eno. The internet at your end is affecting your voice. We are not able to hear you, so there are long periods of silence, sadly. So can we ask that you hold your thoughts? Maybe if you could help us note it down, and then we would come back to you at some point during the session when the internet might have stabilized a bit. We might also find an alternative, maybe in the chat box to our attention as a panelist, and then we'll be able to pick up some of your points from there.
Okay,
so about the delay in the transmission. Okay, so thank you for understanding.
That's noted. Okay.
Thank you for understanding. So I see also that my co-facilitator for the session, Monsieur Leontine, is online as well, and a few other speakers for the other sessions and other colleagues and friends of the African Regional Human Rights System. But I think even from the little we got from Dr. Eno at this point, and like I said, we'll come back to him again, it's already pinpointing some of the issues that we want to resolve on this webinar, or at least begin to talk about. So you have a court that is ready to receive cases and is ready to engage and wants to act in accordance to international law. And then we also have the reservations of state parties in terms of how they view their sovereignty is being challenged by the court and wanting to restrict, despite the court's attempts at repealing Article 34.6 for subsequent protocols, especially the merge protocol, which will come into being once the necessary ratifications have been received. But then, how can we chart a path forward? What would be the answer in terms of creating something that will work for African people within our African context? It would be useful to also hear from the African Commission, their reaction to all of this, particularly when we pick from what has been spoken earlier, that in the Inter-American system, there's actually no direct access. You have to go through the Inter-American Commission. But then the African Commission and the African Court have been engaging since the African Court came into being in terms of how they would work and how they would be able to manage complementarity. And so I would like to find out if on this call we have the chair of the African Commission on Human and People's Rights present, or a representative who can take the floor. Indicate in the chat or by raising your hand virtually. Okay, I see Michael Yako, hand is raised. Can you indicate in the chat your designation so I can give you the floor? Oh, okay, Michael. You're with the Center for Human Rights. So we are not receiving questions at the moment. We want to give the floor, first of all, to the representative of the African Commission on Human and People's Rights. There'll be a time when we'll be able to interact with everyone else. Thank you. So if there's no one from the African Commission on Human and People's Rights at the moment, I would like to then move over to the African Union Commission. We've also have on this call the AU Office of the Legal Counsel, Dr. Namira Nigem. I hope I got your name right, of the Office of the Legal Counsel. I would like to give you the floor in order to also share from the perspective of the African Union Commission. How are you managing this sudden withdrawals that we're seeing? What are the challenges within the system? And what can we do differently moving forward? You have the floor, please. I did see on the participants list, but can you confirm if you, I'll need some help with Secretariat, please, to confirm if they are on this particular thread, but I did see, yes. I think you will need to give her, you will need to open her mic so that she can speak. Okay, thank you very much. So we're just waiting for Dr. Namira's mic to be opened so that we can then hear from the African Union Office of the Legal Counsel in terms of how they've been managing a lot of this. For many years, there's been demand from civil society about ensuring that our protocols and our treaties actually work for African citizens. And there was a time when the African Union Commission led a campaign about compliance to international human rights, to African human rights treaties. So what do we do in this situation now? You have a court that is active, and then suddenly we are seeing an exit of the declarations, which has actually made it possible for individuals and NGOs to be able to access this court. So without much ado, I would like to give the floor to Dr. Namira, and I hope your mic is open now and you can share the reactions, your reactions to this issue. Technology is really a challenge for us these days, but due to COVID-19, we're all having to cope with this new reality of connecting and meeting as well. Secretariat, can you assist Dr. Namira to get her mic open?
Hello, this is the technical team. So Dr. Namira, please join your audio. You have to join the audio from the device that you're using. Just click the button that's written join audio, and then on the options, join using internet audio. Thank you. Alternatively, you can just get off the call and then rejoin. As you rejoin, it will automatically prompt you to join your audio, and you can do so.
Okay, hope that Dr. Namira can get the assistance, the technical assistance she needs in order to join us back and contribute to this conversation. Before moving on, I want to find out from Dr. Eno if he has any notes he's typed, or if his connection is better now and can conclude on his comments. You can also type on the chat. I'll be able to pick it up from there.
Okay.
I can hear you, Dr. Eno.
Should I proceed?
Yes, please.
Yeah.
You have the floor.
Good. Emphasize the domestic judicial system, as well as the danger to their national sovereignty. So it would seem to me that the withdrawals, this is my personal opinion, a national sovereignty rather than anything else. And for me, I think His Excellency Adamadian raises issue. If African states want to promote and protect human rights, not only African states, I think any state that is serious about the promotion and protection of human rights has to trade are no longer within the domestic domain of member states. It is now an international issue because the violation of human rights in one country can necessarily cause international peace and security in that country, in that region, and across the world.
Thank you so much, Dr. Eno. Thank you so much, Dr. Eno, for sharing with us those thoughts. We lost you again briefly.
No, I was saying that I don't know where you lost me, but I spoke for quite a while. But I was saying I can stop here, but I'm available to take questions.
Excellent, excellent. I think that would be a very good place to stop and to move on. And then, of course, in the Q&A, then we can have more specific questions that you could respond to. Thank you so much for sharing your thoughts and for your time at this session. So I understand now that Dr. Namira's audio is working fine and she'll be able to join us. So can I give the floor to the AU Office of the Legal Counsel for their reactions on this particular issue of the Article 34.6 withdrawal by state parties?
Good afternoon, and thank you very much. And I did have technical problems. I'm in parallel meetings, so I had to go to the other meeting and come back. So I apologize for that. Of course, like what I will say will not be the African Union position, because this has not been so far discussed by the member states. So there is no official position on the withdrawals. But from the perspective of treaties in general and the work that we are requested as an office in the organization to carry out, is to promote our treaties and to make sure we have like more engagement by our member states in the process of integrity of the continent. So that will be my first comment, that basically withdrawals of these states will somehow bring us back rather than move forward with regard to the implementation of our treaties. My office is engaged in a huge project to promote the treaties of the African Union, including the human rights treaties and the different protocols. We have another project for the Malabo Protocol. So now I would say that this is a drawback rather than moving forward by promoting our treaties and so on. The other issue is, of course, which is a political dimension. As mentioned earlier, before I left, someone was saying this is the sovereign right of states. So if you're representing any of the states, you have sovereign right to put declarations and withdraw these declarations based on the political situation at a certain point in our governments. So this is something nobody can deny. But the implications of it on the implementation itself and on the work of the court, we are yet to see, because now, as mentioned earlier, that Tanzania has the biggest number of cases. So now in the dock, when you remove this, when you remove all of the cases coming from the countries that have withdrawn, there will be a drop in the work of the court. So for me, this will be somehow lacking the promotion even of the work of the court. If we look at it from the perspective of the wider international community, while we are trying to promote African solutions to African problems and to ensure that we are able to face ourselves issues of be it impunity or amnesty or anything that might escalate to threat the peace in any part of the continent, and all of these issues when it comes to the promotion of human rights and good governance. When we are now deriving from this, it will be somehow difficult to keep defending that we are supporting our institutions. This is where I have another concern, because in most of our rhetoric and the statements we deliver before the ASP, in the ICC and others, we speak of the current court as a success. We try internally in the AU to see if we are going to start the operationalization of the African Court of Justice until the Malabo Protocol enters into force. So with all these instruments that are in place that we are trying to promote and show that they are strengths for the continent in the wider international community, now when we have all of these withdrawals, that will be subject to criticism saying here you yourselves are not supporting your own treaties and documents and so on. So this is where I have a worry, and I just wanted to share these primitive remarks with you. And again, these are my remarks and not the African Union position, because this issue was not discussed by the African Union itself. Thank you so much.
Manak Ibrahima.
Thank you so much.
Ça marche. Ici, nous
I think
voilà, c'est bon.
Colleagues to mute when not speaking, please, so that the flow of the webinar is not disrupted. Thank you very much. So thank you, Dr. Namira, for sharing your thoughts and also for giving some new insights into broader how do we then see the implementation of treaties by African Union member states. If actually we're actually pulling back and drawing back some of the successes that we've already been celebrating and we're showcasing to the world. So at this point, I know that one of the what we've heard from the African Court, we've heard from the Office of the AU Legal Counsel, and we also have civil society actors on the call just to get initial reactions. I can see there are quite a number of people that are also indicating that they want to ask questions. I'll say, please put them in the chat at the moment. And when we're going to open the floor for questions, you'll have the opportunity to ask them or to get responses from the speakers. I would now like to move on a bit slightly to civil society and to call on my brother, Dr. Japheth, who is on this call, to share some feedback in terms of his own engagement with this process and what he thinks we should be doing as civil society, but most importantly, just to give a reflection on the impact of this withdrawal to the court and suggestions as to what we should be doing differently as civil society actors. So Japheth, if you're on this call, can you kindly unmute and then you have the floor. Thank you.
Thank you, Osai. I am on the call. Can you hear me clearly?
Yes, very clear, and I can see you as well. Good to see you.
Thank you. I just want to use this opportunity to make 3 specific points. And the first really is to put the withdrawals in the bigger context in which they have taken place. And particularly to remind us that there is a common denominator, a thread that links all the 4 countries that have withdrawn. The withdrawals really, if you look at them critically, are a culmination and a reflection of the deteriorating domestic human rights situation in the 4 countries. We've seen in the period preceding and heading to the withdrawals, really a shrinking space, civic space in all the 4 countries. In Tanzania, we know at least in the last 4 years, the civic space has been rapidly shrinking. Journalists have been arrested and charged with trumped up charges. We know, for instance, just yesterday, comedian Idris Sultan was in court, and his charge really, the charges against him relate to him laughing. And there's been also a raft of repressive laws restricting the rights of opposition politicians, human rights defenders, activists, and researchers. In Benin, we have seen the same. In the last 2 years, 17 journalists, bloggers, and political activists have been prosecuted under the law on freedom of expression. In Cote d'Ivoire, we've seen the pre-electoral context where the government has multiplied their attacks against political opponents and dissenting voices. So these withdrawals really, if you put them within the broader context, we also have to remember that they have taken, they really reflect deteriorating human rights situation within the domestic context. Then secondly, I think it's also important in the particular case of Tanzania, where previous speakers have said that the majority of the cases, to also remember that most of these cases relate to fair trial, and that they are related to individuals who have not received proper legal representation or any legal representation at all, yet they have faced serious, they have been charged with serious offenses, some of which could attract even the death penalty. And therefore, the problem, for instance, in Tanzania is a broken criminal justice system that the withdrawal in itself will not solve, that the country really needs to think through its criminal justice process and try to fix it, because these cases really reflect that point. The second point that I thought I should make is that we should remind ourselves, and the concerned government should also be reminded, that they are still treaty bound to implement the orders of the court in all the decisions that have been issued against them. Adama Dieng did mention Article 26 of the Vienna Convention. In this regard, we should remember that the courts, the 4 countries have not withdrawn from the protocol establishing the court protocol, and the protocol establishing the court, and they are still treaty bound by Article 30 of the protocol that requires them to comply with all these decisions. So even though they have withdrawn their Article 34.6, they should implement the decisions that they have been made, that they have been issued against them, until full implementation and full compliance is achieved and to the satisfaction of the court and the Executive Council of the African Union that is mandated to monitor implementation. Then thirdly, I think I just need to make a point that the AU Legal Council has also said that when we look at these withdrawals from the bigger context of AU mechanisms for human rights protection, these withdrawals are really a betrayal of the African Union efforts to create and strengthen the regional human rights system. And we know that the AU, for instance, in the 2016 declaration on the theme of the year that focused on human rights, has consistently said that they need to strengthen the African regional human rights system so that accountability and remedy and solutions to human rights victims can be provided within the continent. These 4 withdrawals should be seen as a betrayal of that larger goal of creating critical and strong, credible regional human rights system on the continent. I think I'll stop there, Osai, and maybe answer any questions that will come during the question and answer session.
Yes, thank you so much, Japhet, for your thoughts on this and for actually just throwing light on what we should be looking at the bigger picture and to see what other angles we can use to ensure we hold our governments to account on the issues that they've said they've committed to. So I would like to give the floor to Colette from EURISA, if she's on the call right now, their representative. Or if not, I would like to invite Dayo from the Institute for Human Rights and Development in Africa. Dayo is also a colleague that has done quite a lot of work in engaging with the African human rights system, cases before the court and cases before the African Commission itself and the ECOWAS court. So Dayo, I'm happy to give you the floor for your reactions and contributions to the topic. So you can unmute your mic. You have the floor.
I hope you can all hear me now.
Yes, but if you can speak a bit louder.
Oh,
thank
okay.
you.
Okay, thank you so much. Thank you so much for inviting IHRDA to speak in this important discussion. As many of you will know, IHRDA is an NGO primarily involved in human rights litigation within the African human rights system. And this state of withdrawals is so concerning to us. We currently have cases pending against one of the states that withdrew the declaration, Tanzania. And even though, you know, my senior brother Japhet has mentioned,
help us with we're having translation. So if you could speak to the mic so they could hear you and also interpret.
Okay. Is this better, please? Hello?
Interpreters, is this better? I think go ahead. If there are issues, they will come back to us. Please go ahead.
Okay. All right, thank you. I was saying that, you know, it's been mentioned earlier about the fact that states still have a duty to implement decisions of the court in cases that are currently pending or decisions that have been issued, even when they withdraw those declarations. But then we're concerned about how this would actually play out in practice. For instance, the case we have against the Republic of Tanzania, the state has, even though they initially started participating and submitted a list of their representatives, but then subsequently have not been participating in the proceedings at all. And this is concerning to us about how these states would respond to cases currently pending against them or cases filed within the 1 year that the withdrawals will take effect. We're also concerned that this is an access to justice problem for the several victims which we as an NGO represent. We know of some of the problems of litigating at some of the other continental bodies, and the African Court has been one way to get around some of those problems for those states that have made the declaration. Unfortunately, for these 4 states that have withdrawn, that's no longer there. We think there has to be a way of making this Article 34.6 requirement to no longer, to remove this requirement. And states have to remember that, like has been mentioned a couple of times in this conversation, the reason for the creation of the court is the promotion and protection of human rights within the African system. And this works against that goal. And states have to, we encourage them to remove this declaration. But in the interim, I mean, until when or if this declaration is removed, I think it's important for the African Commission to take up its role to bring cases before the African court. I actually has tried to engage the Commission to do that in a couple of cases, but all these requests were either declined or not even addressed at all. And I think it's important for the Commission to start to do this because for most of the states on the continent, for most of the states that ratify the court's protocol, this is the only way to access the court. Let me stop here, and if there are any questions, I can take them.
Thank you so much, Dayo, for your remarks on the issue. And I also take it that while you said that we need to look at its temporary solution in terms of engaging with the system, you used the opportunity to reiterate that we need to find a way to remove this Article 34.6 limitation that is before all of us. Because now we're also seeing the withdrawal now even leaves you in a confused state as to how to proceed going forward. We know that there are bilingual speakers on this call, and as well as English-only speakers and French-only speakers, and that is why I'm actually co-facilitating this conversation with my brother Aliontine, who is on the call, but also because we want to give an opportunity for people to converse and also interact in as much as possible in both English and French. So before inviting the next speaker, who is Alain Kombo from Congo Brazzaville, I would like to, at this point, step back a bit to invite my co-facilitator, Monsieur Leontine, to actually take the floor, say a few words, and then introduce the next civil society representative to share and comment on the Article 34.6 declaration. And we hope by that time, some of our state representatives would have also joined the call. So, mon grand frère, Monsieur Alion, can I give you the floor? Vous avez la parole.
Bonjour. Ok.
Est-ce que ça marche?
Oui, oui, ça marche. Ça va?
Oui, est-ce que vous m'entendez?
Yes, we can.
Ah bon, vous m'entendez très bien. Donc, moi, je voudrais tout simplement dire que la grande question que nous avons, c'est la régression en matière de droits humains dans certains pays et qui profitent de l'occasion tout simplement pour vraiment échapper au contrôle de la Cour africaine ou de n'importe quelle autre juridiction extérieure. Donc, c'est une espèce de repli. La Côte d'Ivoire, c'est ça. On sait très bien les problèmes qu'il y a avec le mécanisme de régulation des élections. La composition, c'est quand même contesté par l'ensemble des partis d'opposition. Donc, la Cour africaine a donné raison aux organisations de la société civile et c'est contesté par l'État qui d'ailleurs a mis carrément cette organisation de la société civile en quarantaine. Je me rappelle la fois où ils faisaient leur propre congrès, c'était moi-même qui étais allé pour ouvrir. Il n'y avait aucun membre du gouvernement qui était là sur place. Au Bénin, Diafet a raison. Au Bénin aussi, c'est pareil. La dégradation de la situation démocratique et des droits humains au Bénin, c'est quand même effarant. Hein? Tanzanie, c'est pareil. Bon, écoutez, le Rwanda, n'en parlons pas. Hein? On peut avoir beaucoup d'admiration pour la gouvernance de Kagame, mais en ce qui concerne la question des droits humains, il est évident que le Rwanda n'est pas une référence non plus. Maintenant, qu'est-ce qu'il faut faire? Je pense qu'il faut à la fois faire du plaidoyer, c'est important. C'est très important de faire du plaidoyer. Important également, de mon point de vue, aussi, bien sûr, de faire des rapports surtout sur les défaillances des juridictions internes. Et également le contrôle des juridictions internes par les États. Je pense que toutes ces questions sont des questions fondamentales sur lesquelles toute la société civile devrait réfléchir. Et de mon point de vue aussi, comment il faudrait réactiver le network de la société civile en ce qui concerne les problèmes de démocratie, de droits humains. Je pense que ça aussi c'est un problème parce qu'il y a quand même une espèce de défaillance à la fois qu'on peut noter sur le plan des mécanismes de régulation sur le plan international, que ce soit l'ONU, que ce soit la CEDEAO, que ce soit l'Union africaine. Leur impact maintenant sur la situation des pays, que ce soit la paix, la sécurité, les droits humains, ça s'est beaucoup affaibli. Donc, il me semble que c'est un contexte global. C'est dans un contexte global qu'il faut inscrire cette affaire, l'étudier, l'examiner sérieusement et vraiment ensemble voir les voies et moyens pour y arriver, en essayant de voir quels sont les types de communication et de plaidoyer pour chaque cible, que ce soit les mécanismes régionaux, que ce soit les États, c'est très important. C'est pour ça que ce webinaire aussi vient en son heure, en convoquant pratiquement tous les acteurs nécessaires, mais à chaque acteur, il faudrait voir quel type de communication nous pouvons avoir pour les convaincre. Allô, vous m'entendez? Allô? Ça ne marche plus. Salimata.
Yes.
Ah, vous m'entendez? Très bien, voilà. Je pensais que vous m'entendiez plus.
Yes.
Voilà ce que je voulais dire en guise d'introduction, quoi.
Thank you. Thank you very much. Thank you very much, Monsieur Tin, for your initial reactions. I would now like to give the floor to Alain Kombo to share civil society response in terms of what is it that we can be doing differently, but most importantly, what this withdrawal means also to human rights advocacy, campaigning, and work in the region. Thank you. I will ask Mr. Kombo to unmute. You have the floor.
Merci beaucoup. Et nous pensons que dans le cadre de défense de la gouvernance, de l'intégrité territoriale et de l'indépendance de tous les États membres de l'Union africaine, et nous avons eu cet outil qui est la Cour africaine. Et nous nous battons pour permettre l'accès à la justice à tous. Et nous pensons que ces mécanismes est un bien très profitable pour nous. Mais ce qui est vrai, c'est la non-appropriation à cet instrument africaine. Donc, les institutions comme la justice, nos institutions nationales, et même l'université, ils ne connaissent pas réellement le bien fondé de la Cour. Et nous pensons que nous devons faire un grand plaidoyer à ce niveau parce que c'est un grand vide lorsque on lance la Cour a besoin des magistrats. Nous ne voyons pas l'engouement des magistrats nationaux pour positionner leur candidature. Et ce qui revient à dire qu'ils ont vraiment une méconnaissance sur la Cour africaine et aussi sur les droits de l'homme. Et c'est la même chose lorsque nous discutons avec les parlementaires sur la Cour africaine. Ils connaissent moins la Cour africaine. Et nous sollicitons peut-être qu'il y ait des descentes des pays membres de la Cour africaine dans des États pour discuter avec les parlementaires, avec les ministres, afin qu'ils puissent leur donner une connaissance exacte sur la Cour africaine. Et nous avons dit, quand il y a le renouvellement des mandats des juges, il n'y a pas beaucoup de magistrats qui manifestent leur intérêt sur cette Cour africaine. Ainsi, nous avons une grande responsabilité en tant qu'ONG parce que nous pensons que cette hémorragie que nous sommes en train de vivre aujourd'hui, le retrait de certains États membres de la Cour africaine, c'est en partie notre responsabilité. Nous ne travaillons pas de sorte que la Cour africaine puisse avoir un peu plus de poids dans chaque État où nous sommes. Si nous pouvons organiser un peu de visites, comme nous l'avons dit, si nous pouvons organiser un peu de visites dans des États pour discuter avec les autorités et permettre qu'il y ait des membres qui devraient travailler pour un programme d'aide judiciaire. Et cela n'est pas suffisant parce que nous pensons aussi que ce grand problème, c'est une grande responsabilité politique. Et notre défi ne peut pas s'arrêter parce que la justice, l'État ou les membres politiques veulent freiner l'accès à la justice à tous. En réalité, la raison d'être de la déclaration du protocole est une restriction à l'efficacité de la Cour africaine des droits de l'homme. Pour preuve, depuis l'entrée en vigueur de nombre de déclarations, jusqu'aujourd'hui, ça n'atteint que 10. Et avec le départ de certains, malgré qu'il y a 30 États partis, et aujourd'hui, il n'en reste que 6. Dans le sillage de la déclaration de l'article 34.6 des 10 États en cause, il ressort que c'est plus des individus et des ONG qui saisissent la Cour, c'est-à-dire en matière à révéler dans le respect des droits de l'homme en Afrique. En vertu de cette réalité et face aux violations toujours que nous avons constatées des instruments de protection des droits de l'homme, il y aurait mieux que le verrou d'une déclaration préalable de la reconnaissance des recours individuels soit levé. La réticence des États partis à autoriser l'accès direct à la Cour africaine par les individus est du fait que c'est plus la population au sens large du terme, c'est-à-dire qui n'ont pas le pouvoir décisionnel, qui sont des victimes de la violation des droits de l'homme. Donc, ce n'est que dans cette catégorie d'acteurs de la société que les plaintes devant la dite Cour peuvent façonner. Et conscient de la réalité et dans l'option de la garde, la réputation de leur gestion de la chose publique, le pouvoir ne daigne octroyer cette brèche à des acteurs. C'est une question d'ordre purement politique. Mais nous pensons que nous avons encore un grand travail dans nos États pour que nous puissions continuer à travailler afin d'arrêter le retrait de certains États partis au protocole de la Charte africaine des droits de l'homme et du peuple. de la Cour africaine des droits de l'homme. Et ceci, c'est pour nous permettre d'avoir toujours accès à la justice et peut-être chercher des manières de plaidoyer pour que nous puissions encourager nos États à ratifier. Et si avec le temps, je suis de pair avec notre collègue qui a parlé d'enlever cette partie de ratification pour qu'on puisse plus permettre aux États à tout moment de retirer leur partie, de ne plus permettre aux ONG, aux individus de saisir la Cour. Et nous demandons, nous pensons que nous pouvons aussi chercher à améliorer des mécanismes d'adoption des tests de l'Union africaine et soumettre l'entrée en vigueur de droits dérivés de l'Union africaine au vote à la majorité simple. C'est ce que j'avais à partager. Merci.
Thank you so much for your intervention and also for sharing your insights in terms of what we need to be doing going forward. I'm also very mindful of time, but there have been a few questions and comments in the chat box and in the Q&A, which I think it would be useful to ask now so that panelists can share their thoughts before we move on to the next session. There's actually one to Dr. Eno in the chat. It's from Wade Macmullen. And the question is, I'm interested to hear more of the reasons given by the court in its various requests to repeal Article 34.6 or exclude that type of direct access in the Malabo Protocol. If your intervention was understood correctly. So Dr. Eno just notes that particular question. And we also have a comment for Mr. Dama Dieng. Wilson suggests that talking about indirect access to the African court, that is aware that countries which have not made it can also access the court through the African Commission, which is correct, and that there are examples. And he mentioned Gaddafi versus Libya and African Commission versus Kenya. And further requests, can we not capitalize more on this as an alternative to the encumbrance posed by Article 34.6? Then there are also two other people that want to take the floor to ask their questions. So I would like to give the floor to Dr. Eno first to respond to this, to the question that was directed specifically at him, or if it's easier to type it in the chat box to all panelists and attendees so everyone can see it, if internet is still a challenge in hearing him speak.
Sorry, Madam Moderator, what is the specific question?
The question is, can you share in more detail the reasons by the court in various requests to repeal Article 34.6? On what basis did the court ask the African Union to repeal Article 34.6? And also in reference to the Malabo Protocol.
Yeah, okay.
So you can share now.
Thank you. No, I was saying that the court, can I proceed?
Yes, please.
Okay. No, I was saying that the court has, on a number of occasions, Article 34.6. The first instance was in 2009, when the court was called upon to make contributions on the establishment of the merged court. In its report, the court proposed that Article 34.6 should be repealed and should not feature in the merged court. This was rejected. In 2015, the court made another proposal within the context of its 2015 activity report. This was again rejected, And in January 2016, still within the context of its activity report, the court made the same proposal and it was again rejected. So the court has concluded that member states are reluctant and do not want to repeal Article 34.6. And so the court has now decided to rather engage member states to ratify the protocol and at the same time deposit the declaration under Article 34.6. So very briefly, that is the response I can give.
Thank you very much, Dr. Eno. I would like to give the
floor. Thank you.
Thank you very much. I think the comment was the reaction to Mr. Adama Dieng's presentation was a comment, so I'm going to leave that aside. But there are two participants that have requested the floor to just share a few things. One is Michael Yanko from the Center for Human Rights. I would need help in giving him the floor to share his comment, and I would ask you to keep your comment or your question to under 2 minutes, please. And then the second person that I would give the floor to would be Yare Fo. So Michael Yanko, you have the floor. I hope I can find you on the list, or if the Secretariat can help me.
Can you hear me?
Yes, we can hear you.
Yes, thank you very much. I have a question that I wanted to ask someone from the Commission, if anyone has an idea. In terms of complementarity between the African Court and the Commission, it appears that somehow the Commission has retrogressed in its new rules of procedure. Under the 2010 rules, the Commission could refer cases to the court in instances, including if states fail to comply with provisional measures or merits decisions, or in cases where they consider there to be serious rights violations, that they would refer the case directly before even considering to take any of the steps. But unfortunately, in the 2020 rules, which just came out a couple of days ago, the only circumstances which the Commission seems to consider itself capable of referring cases to the court is before they consider admissibility. So the Commission seems to have eliminated the other options of, for instance, if the Commission made its own recommendations and was ignored by the particular state party, or that even made provisional measures and those were ignored, the Commission doesn't seem to consider itself capable of referring those kinds of circumstances or scenarios to the court anymore. I just want to find out if anyone from the Commission can explain why these kind of, if you like, potentially retrogressive measure has been taken in the new rules of procedure. Yeah, thank you.
Thank you very much. I'm not sure whether someone on the Commission is on the call right now, but we'll remind them of this question when they do join. The second person for this session, final person for this session that would give the floor to is Yari Fall to ask comment or question.
Osai?
Yes? Yes.
Madam Moderator?
Yes, I can hear you, Dr.
Good.
Yes, I can hear you.
Can I attempt? I have. There was a similar question on the Q&A, but if you don't mind, I can attempt a response to the.
Please proceed. Thank you.
Last question. Yes. To have now only one condition under which they can seize the court, which is before before they decide on admissibility. Under the old rules, the 2010 rules, there were 4 different instances where the commission has made a decision where they failed to comply. And the 4th condition, which was general, was any other instance where the commission deems it necessary.
Dr. Eno, there's a delay in receiving your comments.
Implementation of that, the commissions on that. So what do we do?
No, please proceed. It's improved, so please proceed.
Yes. I was saying that the commission's understanding of complementarity was that when a state fails to implement it, the court should immediately take action to ensure that that commission decision is implemented. Understanding of complementarity is that being a judicial body, it cannot rubber stamp any decision of the commission. It has the mandate and the judicial power to open a case and look at it de novo. So that has been the bone of contention between the commission and the court in the understanding of their role in the complementarity setup. Now decided that, okay, bring to you, if you have to look at it from scratch, if you have to look at it de novo, it's when I have not made any decision on admissibility. So that is 0.18 to what it is at the moment. I thought I should give this background so participants can follow. Thank you.
Thank you very much, Dr. Eno, for that. And it's kind of clarified also why we have this sort of gap between the transfer of cases between the commission and the court. So the final intervener for this session would be Mr. Yere Fall. You have the floor. I hope the Secretariat have been able to locate on the participants list so that we can unmute the participant to ask the question or comment.
Hello?
Please proceed. Thank you.
Vous m'entendez? Bonjour à tout le monde. Et peut-être la première chose que je vais dire, c'est que on prononce mon nom à l'anglaise, on dit Fall, alors que mon nom c'est Fall. C'est pas Fall, comme vous le dites en anglais. Alors, cela dit, je voudrais quand même attirer l'attention des collègues qui disent qu'il faut supprimer l'article 34.6, que ce n'est pas une bonne idée du tout. Parce qu'aucun État n'acceptera de signer le protocole s'il s'avère qu'il va le faire ad vitam aeternam. Il faut leur donner la possibilité de s'engager et de se retirer. Le problème, je crois, se situe à un autre niveau. Quelqu'un l'a dit tout à l'heure, le droit conventionnel, c'est un droit de bonne foi. On y entre de bonne foi. On ne peut pas participer à un jeu et dire, si les règles me sont défavorables, je me retire. Ce n'est pas possible. Quand vous entrez dans un jeu, vous en respectez les règles et si vous les violez, vous subissez les sanctions. Je pense qu'il faut convaincre les décideurs que, quand même, le droit, c'est ça. Quand vous enfreignez une règle de droit, la conséquence logique, c'est la sanction. Quand vous signez un accord international, vous ne pouvez plus vous réfugier derrière une quelconque souveraineté pour dire non, 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 c'est contraire à ma souveraineté. Vous abandonnez une partie de votre souveraineté en signant une convention internationale. Je crois que c'est à ce niveau qu'il faut convaincre les États. Il faut absolument que nos États comprennent que le droit international, c'est un abandon de souveraineté. Et lorsque vous abandonnez une parcelle de souveraineté, vous confiez votre destin à ceux qui sont chargés de vous juger. C'est ça la règle. Je pense pour ceux d'entre vous qui connaissez les dispositions qui régissent les matchs de basket. Lorsque vous contestez les décisions de l'arbitre, en plus de la première faute, on vous colle une seconde faute. On vous pénalise une seconde fois parce que vous avez simplement contesté la décision de ceux qui sont chargés de mener le jeu. Donc, c'est ça les règles du jeu. Il faut que tout le monde l'accepte. Moi, je crois que c'est ce travail-là qu'il faut faire. Convaincre tout le monde que ce sont des dispositions légales que tout le monde doit respecter et que personne n'a le droit de les enfreindre. Et si vous les enfreignez, normalement, il y a une sanction et cette sanction est décidée par des gens à qui on a confié la cour. Maintenant, il faut faire en sorte que cette cour soit absolument irréprochable à tous les niveaux, que ces décisions soient légitimes et que personne ne puisse les contester. Qu'est-ce que ça veut dire? Qu'il faut recruter au niveau le plus élevé, au niveau le plus compétent et au niveau le plus efficace. Comme ça, toutes les décisions vont être acceptées par tout le monde. Moi, je crois que c'est ça le nœud du problème et c'est dans ce sens-là qu'il faut travailler. En tout cas, moi, c'est ma conviction profonde. Merci beaucoup.
Thank you so much to your father. Yes, thank you so much. So moving ahead now, the next segment, I noticed that we had one other comment on the, just give me some time to read that out. Okay, so it's from Lloyd, and his contribution is that CSOs must work closely with the African Court in engaging individual states in a robust way and convince them to ratify the court protocol and deposit the Article 34.6 declaration. Of course, this is something that has been shared already by some of the speakers and also by the court registrar, that this could be one way through which we can combat this. So, moving on now, I would like to hand over to Dr. Chidi Odinkalu to take us to the interactive session. And of course, if there are any state representatives in the house, it would be good if they indicate in the chat or they raise their hands, and then we'll try to give them the floor throughout this interactive session as well. I think a good point to take us into that session is a statement by Ikechukwu Uzoma, who said, while we consider alternatives for access to the court, could there be approaches to guard against a second wave of withdrawals? Does the court have state party allies? So I think let's begin to think now more pragmatically, more creatively, how do we go about ensuring access to the court does not suffer drastically as a result of these withdrawals, and what we can do going forward to also get more declarations. Thank you all for your active participation in this session, and I would now like to hand over to Professor Chidi. Thank you.
Thank you, Osai. Good afternoon, good day, colleagues, wherever you may be across the world. We are now in the open forum, I presume. Is that correct?
Yes, we are.
Yes, thank you. And we had colleagues listed from different places to kick us off on this or to participate in this, or at least help us. So we'll continue taking questions from the chat to the extent that that is possible. But I think I saw Colette somewhere here. And I also noticed that the most marginalized parts of Africa also participating. Lucia da Silveira is participating from Luanda. And I wanted to suggest that we start from hearing both of them. I don't know whether we've got Lusophone translation, but even if we don't, Lucia can speak in tongues and we'll translate using the Holy Spirit. But it will be useful to hear both Colette and Lucia before we proceed to the other colleagues, if that's acceptable. Colette, please.
Good afternoon. Your Excellencies, I want to acknowledge the presence of Professor Chidi Odinkalo. And I know that we have honorable judges here and members of the African Commission, the chairperson, honorable chairperson of the African Commission, and other distinguished representatives that are here. It is my honor and privilege to be part of this important meeting, and thank you very much for connecting with us in this important debate. I think the issue of the withdrawal is like step, like a backlash of some sort and discouragement of all the gains that the civil society advocacy has done for so many years. And I think that there has been a lot of focus around the declaration, that the declaration has deposited something that strengthened the power of the civil society to access justice directly when violations of human rights are not properly addressed at national level. And now we have seen numbers dwindling down, actually like discouraging us to say that we will not grant you justice. But we have not been doing a lot in terms of exhausting other structures that can enable the court to address human rights violations. For example, in a country like ours, we have a ratification. However, what is outstanding is a declaration. How can we bypass that stumbling block that disempowers me to access the African court? Because the kind of sexual violences that we are experiencing in Southern Africa, especially in South Africa, it has gone beyond comprehension. It has gone beyond description. It has gone even beyond describing it as war, sex, rape used as a weapon of war. It has it's completely out of those definitions. It requires another way of being dealt with. Now, Article 5, one of the protocol established in Africa, it lists people that have got access, that those that can assist us in bringing matters before the court. I know the African Commission is one of them, besides others like national human rights institutions and other organs of the AU. They enjoy jurisdiction to bring matters on our behalf, and they can become complainant. They can occupy that position of complainant. And they can do so to those countries that have ratified, not necessarily seeking them to show that we have actually signed a declaration, but ratification on itself is sufficient for these institutions to help us access justice. So I was looking at how, are we still on?
Yes,
I was just thinking that how can we improve our strategies now that we're having COVID-19, and COVID-19 has taken precedent over and above all the challenges that we have. Sexual violence is one of them. And poverty, unemployment, it's increasing. And we have a situation where even policies of sexual violence are non-existent in some of the AU institutions. The Protocol on the Rights of Women in Africa, it also provides an opportunity that the court is vested with the powers to interpret. When you look at the provisions of the African Charter on Human and People's Rights, the civil society or NGO organization, they can directly approach the court for interpretation of the African Charter on Human and People's Rights, where we feel that the problems, the Commission is having a problem in terms of interpreting or providing remedies or solution to the problems that civil society is facing. However, that is not speaking to all of us. It has got a lot of limitation because that article, under Article 45, subsection, I'm not sure it's G or H, it's specific. It's looking for an organization that is recognized by the AU as an African NGO. It's not everyone. It's not NGO with observer status. It is an NGO that is recognized, and that NGO could be an NGO with MOU. It's an NGO that, and those NGOs, I don't see them risking their MOU, for example, to assist us to bring matters to the African Court on Human and People's Rights. In actual fact, it means...
Okay, Colette, I'm wondering, can we pause there so that we can bring in other people as well, if you don't mind? I think you've raised two very substantial issues. One is availability of the court mechanism for remedying sexual violence, particularly given the problems we've got at the moment. And the second is the question of standing to procure or standing to deploy the advisory jurisdiction of the court. When we've got a significant collection of these, I would want to return on those two questions to Don Dea, who will be closing us off anyway. I hope he can address those in his closing remarks. And probably Dr. Eno, who is the registrar of the court, before we close. But I wanted at this point to suggest that Lucia da Silveira comes in. Angola is the only country that so far made the, ratified the Malabo Protocol, which actually would have given criminal jurisdiction for some of the things that you're talking about. And I wanted us to at least acknowledge that in Lucia's contribution. While Lucia is speaking, can I take liberty as well? I see that Professor Gerard Nyungeko is with us on this meeting. He was the first, he's the first judge president of the African Court. And I'm wondering whether after Lucia, we cannot, I'd like to suggest we take Judge Nyungeko, even if it is just to say, continue with what you're doing. You know, this is Africa and we love our elders. Lucia, please, and then Judge Nyungeko. Lucia da Silveira, I see you. You're here as Maria. Maria da Silveira, can you unmute yourself, please?
Can you hear me now?
Yes, thank you.
Hello. Good morning. No, good afternoon to everybody.
Good afternoon.
Osai, how are you? So
I'm doing
first of
well.
all, I'd like to thank you guys to put the Lusophone on the loop. As you know, we have been discriminated forever. I'm just going to speak in English in respect to my friend Osai, Robert Eno, and the judges that are present, because as for some people here, they've never done anything to make sure that we are represented. So thank you very much for including us. As you know, Angola has just ratified the protocol. For us, it's very important because, you know, we have been fighting for Angola to be part of the process, not only the African Commission, but also to ratify the protocol. Of course, there are mixed feelings when it comes to the President João Lourenço deciding to ratify it. You know, we are coming very close to the elections, but for us, it's very important. And I'm quite sure that Angola is going to declare the Article 34. But my main concern right now is that as civil society, we are still not very familiar with the whole process, the African system process, one, but also how it works and what can be done for us to be more present and more participative in terms of presenting cases, because there are a lot of cases, and the cases that have been presented to the African Commission was not by Angolan civil society. So for us, because of the language barrier, there is still a lot that we are learning. So it's very important that the coalition have that in mind, that there is still a need to empower the Lusophones with the information, with training regarding the whole process, so we are able to present cases, even in Portuguese or in English, that we'll do. So we still have a small group of people that are familiar with the African Commission. Governments are more interested in the UN system, so they don't talk a lot about it. Right now in Angola, few people know that the Angolan government have ratified the protocol. So there is a need to inform other people about it. And as you may know, for us, when the government ratifies an international document, is domesticated automatically. So right now we have a resolution from the National Assembly saying that the protocol has the same power as the national laws, but a few people have access to it. That's what we are trying to do right now as AJPD, is to make sure that people have that information, and also try to translate the protocol, because that's also an issue. Most of the documents are in English, French, and Arab. So civil society have been trying to translate the document into Portuguese to make sure that lawyers in Angola have access to it, to understand it and see how they can also use it while litigating in the national courts. Only once I heard a judge in Angola using even the African Charter as an instrument while judging a case. So we still, you know, behind everything because of the language barrier. Regarding the withdrawal, I think it's natural that it happens, because states do not want civil society to have direct access to the court, and it's normal. Right now, for me, it would be more natural that Angola was withdrawing, but Angola also needs to be in the process, because internationally, Angola needs to be recognized. They need to be seen as a country that is part of the process. So I understand that. And in most cases, we feel that they don't really even understand what the protocol is, you see. So and later on, they will realize how it is. This is our fear. But we have a meeting with the Minister of Justice next week, and one of the things that we are going to discuss with them is is for them to declare the Article 36(4). So this is all I have to say about it. And please, the next time you invite me, remember to have Portuguese translation, okay? Thank you very much, Chidi, for everything.
Thank you ever so much, Lucia. I'm glad that this has been a very enlightening contribution. And if you have wanted another 5 minutes on behalf of Mozambique, Guinea-Bissau, and Sao Tome, I'm sure that we would have found it for you. But just to transition to Judge Nyingeko, and as we say that, I think it's important to recall, particularly given the remarks by His Excellency Adama Dieng, and also the participation of Dr. Namira from the African Union, that actually Article 34(6) was the invention of Dr. Sheikh Ahmed Badawi. Sheikh Badawi was an Egyptian diplomat, was a member of the African Commission. As a matter of fact, he was a chair of the African Commission, and a member of the Committee on Economic, Social, and Cultural Rights. But when the breakdown in the negotiations occurred as to what to do with access, he was the person who came up with the right of individual petition at the last minute, as a last minute compromise between to really enable us to make progress. I say this in the hope that the legal counsel to the African Union, who is also from Egypt, will help us to protect the institution of Article 34(6) from all those people who would rather not wish it well. But I'll hand over to Judge Nyingeko, if you can please unmute. Then there's been a hand from B. Aksen Desiré Nene. I don't know whether I get the name right. After Judge Nyingeko, can we take you, please? Thank you. Monsieur le juge. Monsieur le Président. Has he left? Okay. While we try to locate him, B. Aksen, you're not an Arsenal supporter, are you? B. Aksen Desiré Nene.
Bonjour, est-ce que vous m'entendez?
Oui.
Merci beaucoup. Le nom a été bien prononcé. Je suis effectivement Dr Arsène Désiré Nénébi. Je suis de la Côte d'Ivoire. Je suis le président de l'ONG Action pour la protection des droits de l'homme.
Proceed, please.
This is the host speaking. Be a son, please. If you're going to speak in French, go to the interpretation and on the options, select French as opposed to English. Please select French and then unmute yourself and then start now. Thank you.
Okay, while he's doing that, can the technical support please unmute Judge Nyungeko? He's still here, but he's muted. And Ezekiel Krimwani, could you please stand by on the queue?
C'est bon, vous m'entendez?
Oui.
Allô, vous m'entendez?
Mm-hmm. Can you proceed, please?
D'accord, merci. Donc, je indiquais que je voulais faire aussi quelques propositions, mais avant, je voudrais remercier tous ceux qui participent à cette réunion pour toutes les contributions qui ont été faites. Alors, moi, je voudrais réagir d'abord par rapport à l'article 34.6. Moi, j'ai un avis contraire par rapport à ce qu'a dit mon aîné Fall. Pour moi, c'est parce que quand on analyse cet article 34.6, en réalité, cet article 34.6 est une reprise d'une ancienne version du fonctionnement de la Cour européenne des droits de l'homme. Les Européens sont passés par cette méthode et ils ont vu à un moment donné les limites des dispositions de cet article-là, et c'est ce qui va les pousser, n'est-ce pas, à retirer totalement cette déclaration qui était attendue des États, pour faire en sorte que désormais, tout État parti au Conseil de l'Europe soit directement justiciable devant la Cour africaine. Je pense qu'aujourd'hui, eu égard au fait que dans la charte, dans l'acte constitutif de l'Union africaine, la question de la défense des droits de l'homme est un point important, il faut que dans notre plaidoyer, on puisse faire la proposition suivant laquelle
BSN, unfortunately, we have had to mute you again. Please try switching to French before you start speaking. Right now, you're on the English channel, and your voice is colliding with the voice of the interpreter.
Ok, j'y vais là.
BSN?
Oui, c'est ce qui est activé. Hein. Pour moi, c'est le français qui est activé là.
You're not on. I should not be able to hear you because I'm currently on the English channel.
Okay, sorry. While we are sorting that out, can you please? I'm having problems being able to unmute Judge Nyungeko. Can someone please help me unmute him? I can't seem to be able to unmute. He's muted. But there are also hands from Registrar Eno and Legal Counsel Dr. Namira. The name is Gerard Nyungeko, Nyungeko. Okay, he's unmuted now. Thank you. Mr. Judge President, please. Hello? Professor Nyungeko?
Yes, can you hear me?
Yes, sir. Thank you.
Sorry, I was out, so I don't know what you are requesting me to do.
No, we can't have this without hearing from the first president of the African Court. That would be sacrilege.
I think I missed part of the previous debate. So if you can brief me a bit and precise what do you want me to talk about?
No, no, that's fair enough. Actually, you're an institution by yourself, so anything you want to talk about is fine by us. But we took His Excellency Adama Jang's opening remarks, which recalled the history of Article 34.6, the negotiation of the African Court.
I was following, I was there, yes.
Okay, so we've heard contributions from South Africa and from Angola about different aspects of this conversation, the limitations of the African Court with reference to jurisprudence and access on things like sexual violence, for instance, the limitations with reference to access to the advisory jurisdiction of the court, the long-standing marginalization of the Lusophone countries and failure to make even the texts available to Lusophone countries of Africa so they can participate effectively, and how the jurisprudence can be better disseminated across African countries. Those are some of the issues. You may wish to address those or indeed any other thing. As I said, on the African continent, our elders are very important to us, particularly now that coronavirus is targeting our elders. We need the memory.
Okay, I guess I can speak French?
Yes,
to
sir.
be more comfortable?
Yes.
Do we have interpretation? Yes?
Yes, we do. Technical support, can you please?
Bien. Merci beaucoup pour avoir organisé ce séminaire et pour m'inviter spontanément à dire quelque chose sur cette question qui nous préoccupe tous. Je vais peut-être rapidement évoquer, en ce qui me concerne, les raisons pour lesquelles les États ont aujourd'hui tendance non seulement à ne pas faire la déclaration, mais également à retirer la déclaration qu'ils ont faite pour ceux qui l'ont faite. Vous avez expliqué ou rappelé les raisons qui ont été avancées par les États en question. Mais au-delà de ces raisons spécifiques, circonstancielles, je pense qu'on peut généraliser, identifier un certain nombre de raisons qui empêchent les États à faire la déclaration et qui poussent d'autres États à retirer la déclaration qu'ils ont faite. Je crois qu'on peut en identifier 4. La première raison qui a été déjà évoquée, c'est l'attachement très fort qu'ont les États africains à leur souveraineté. Et cet attachement semble être une des causes communes, comme d'autres l'ont indiqué, au retrait des quatre États concernés. La deuxième raison, c'est la sensibilité particulière de la question des droits de l'homme au sein des États africains. Les droits de l'homme sont une question politiquement sensible, spécialement, comme d'autres l'ont indiqué, lorsque dans un pays donné, il s'oppose de sérieux problèmes de violation des droits de l'homme. J'ai tendance à croire que les États seraient davantage prêts à se soumettre à la justice internationale en matière de différends de nature économique, par exemple, qu'en matière de droits de l'homme. Et si vous prenez les cas du Bénin et de Côte d'Ivoire, tout le monde a noté que ces retraits de la déclaration sont intervenus en rapport avec des questions politiquement sensibles. Même chose pour le Rwanda en son temps. La troisième raison générale qu'on peut identifier, c'est la crainte par les États de faire l'objet de plaintes massives pouvant les déstabiliser à l'interne. Et je crois que, par exemple, la Tanzanie, même si ce n'est pas la raison officielle avancée, en Tanzanie, le fait qu'il y ait eu un grand nombre et qu'il y a toujours un grand nombre de requêtes impliquant cet État a pu jouer un rôle. Et on observe de même qu'à partir du moment où un État fait l'objet d'un nombre qui commence à croître, un nombre croissant de plaintes, même si c'est au début, eh bien les États ont tendance à se retirer ou à être réticents parce qu'ils redoutent qu'il y en ait d'autres et que l'ensemble de ces plaintes puisse les déstabiliser. Enfin, une autre raison que l'on peut identifier, qui n'est pas toujours exprimée explicitement, c'est la crainte des implications financières potentiellement élevées des décisions de la Cour en ce qui concerne les réparations et les compensations. Ici, même si ce n'est pas dans la déclaration officielle du Bénin, je pense qu'on peut considérer que une mesure de compensation dans une affaire où la Cour a octroyé des montants très, très élevés au titre de réparation a pu jouer un rôle dans le retrait de cet État. Donc, au-delà des raisons spécifiques clairement affirmées par les États, je pense qu'on peut extrapoler, généraliser, trouver un certain nombre de raisons. J'en ai indiqué quelques-unes, il y en a d'autres. Le deuxième point que je ne sais pas si le temps me permet d'aller plus avant.
You can finish that point.
Pardon?
You can finish the second point. Yes, please.
Bon, le deuxième point, c'est qu'est-ce qu'il faudrait faire pour renverser ces tendances? D'autres intervenants l'ont déjà dit. D'abord, qu'est-ce que la Cour africaine elle-même peut faire? Premièrement, et je crois que le greffier de la Cour l'a bien mentionné, la Cour ne doit pas se sentir coupable de quoi que ce soit dans ce phénomène de retrait, parce que ce sont les États qui assument la responsabilité de leur décision unilatérale de se retirer. Mais deuxièmement, la Cour, en même temps, doit continuer à s'attacher à délivrer des arrêts de la plus haute qualité possible pour essayer de limiter les occasions pour les contestataires de trouver des raisons objectives ou plus ou moins objectives de se retirer. Et comme nous le savons tous, la qualité des jugements d'une juridiction sont la base de la légitimité, de la crédibilité, de l'autorité de cette institution. En troisième lieu, je crois que la Cour devrait continuer effectivement à sensibiliser les États dans les différents forats, à l'occasion des sommets de l'Union africaine, et de continuer les visites de sensibilisation auprès des États, ne jamais relâcher. Bien sûr, dans le cadre de cette sensibilisation, la Cour devrait se préparer à répondre aux arguments qui sont avancés par les différents États qui se sont retirés, d'abord pour essayer de les convaincre de revenir sur les décisions de retrait, et ensuite pour également convaincre d'autres États qui, bien entendu, sont au courant des raisons avancées par les États qui se sont retirés. Ensuite, que peut faire la Commission africaine des droits de l'homme et des peuples? D'autres l'ont évoqué, je ne vais pas m'y attarder. Premièrement, je pense que la Commission devrait maintenant pouvoir introduire auprès de la Cour un plus grand nombre d'affaires. Et je suis heureux d'apprendre que la Commission a récemment décidé de modifier son règlement intérieur de façon à pouvoir soumettre à la Cour des affaires dès qu'elle les reçoit. Parce qu'auparavant, il y avait un problème de compréhension de cette complémentarité. Je ne vais pas dans les détails, je pense que d'autres en ont parlé, mais ce problème est résolu et c'est une bonne chose. Ensuite, la Commission devrait pouvoir également continuer à faire la promotion de la Cour, comme elle a un mandat de promotion du système africain des droits de l'homme et des peuples et qu'elle avait déjà intégré dans ses activités la promotion de la Cour. La Commission devrait également pouvoir continuer à travailler dans ce sens. Enfin, que peuvent faire les organisations de la société civile, ici largement représentées dans ce séminaire? Je pense que les organisations de la société civile peuvent faire trois choses. Premièrement, elles devraient saisir, quand cela, bien sûr, apparaît approprié, la Commission africaine des droits de l'homme et des peuples, davantage d'affaires, dans l'espoir que la Commission puisse saisir la Cour, donc dans le cadre de cette saisine indirecte. Et je pense que les organisations de la société civile sont bien outillées pour identifier les affaires qui pourraient rentrer dans le champ des affaires que la Commission peut soumettre à la Cour pour permettre à celle-ci d'établir une jurisprudence pouvant impacter l'ensemble du système africain de protection des droits de l'homme. La deuxième chose que les organisations de la société civile peuvent faire, c'est de jouer activement leur rôle d'amis chicouriers, d'amis de la Cour. Parce que l'expérience a montré, tout à l'heure, j'évoquais la qualité des jugements, j'évoquais l'importance de cette qualité. L'expérience qu'on a eue à la Cour a montré que les contributions des ONG en tant qu'amis chicouriers pouvaient, disons, contribuer à la qualité des décisions de la Cour. Et enfin, troisième chose, je pense que vous l'avez, je vais conclure, monsieur, les ONG de la société civile devraient continuer à inclure dans leur stratégie, dans leur plan stratégique et plan de travail, la promotion de la Cour. Je vous remercie, je m'excuse d'avoir été peut-être un peu long, mais vous semblez m'avoir invité à m'exprimer sur les choses que je souhaitais dire. Voilà les quelques observations que je voulais faire. Je vous remercie.
Thank you, Mr. Judge President. That piece of historical knowledge is invaluable, and I'm glad we've been able to get it here. And it's probably a good segue to the transition to done. I think we should be, when do we close? We are closing in about 10 minutes, is that correct?
Yes. Initially, the advertised time was 10 minutes.
Yeah.
I don't know what you intend me to do. Do you intend me to make remarks that close it? Or do you want to just one or two points and then see if there's anybody else who wants to speak? Or we let those with their hands up to speak first?
Well, we've got to manage the time. That I just wanted to be sure about that before transitioning to you, because you're the doyen of a lot of the questions that have come up. But I note that Dr. Namira would like to say something, and Dr. Eno would wish to say something as well. Can we at least get those in and then transition to you, Don, for the closing?
Okay, thank you, Chief.
Thank you. Dr. Namira, please.
Yes,
Legal counsel.
Yes, just quickly, I have one comment regarding the language.
Who is speaking now?
Dr. Namira, legal counsel to the AU. Yes. And then Dr. Eno, registrar of the commission, will speak after her, and then we'll transition to Don.
Okay, it's just like it will take a minute. I just wanted to comment on the issue of the languages, because the Lucifer speaker addressed the issue that the documents are not available in Portuguese, which is not true, because Portuguese is one of the working languages of the African Union for such a long time. And since it was adopted to have Portuguese, we have all the protocols, treaties, and decisions and reports in the four working languages of the African Union, namely English, French, Arabic, So in Portuguese, maybe they just need to know how to access them, but they are available. And when it comes to the treaties, we are adopting, like now I have launched a new treaty page where it will is more user-friendly for all the 4 languages to be able to access all our treaties and protocols. I thank you very much.
Thanks a lot. And we are very grateful actually that you can join us from Addis, because there is substantial internet shutdown in Addis at the moment, and whatever the miracle is that has made this possible.
No, actually, I'm in Cairo. That's why I was able to reach you.
Okay. All right. Thanks a lot, ma'am. Dr. Eno, please. Are you able to?
Okay, thank you, Yeveko. Just to say, yes, I had raised my hand to take us back to the questions that he's saying his raised 4 questions, and I'm very happy that the former president, President Ngeko, has responded to each of those questions. To hear from you, and I'm glad to hear that Angola has ratified the protocol, but I've just checked the AU website, and maybe the legal council not yet rated on the AU website, but I also need to inform Lucia and participants at the domestic level, but do not deposit the instrument of ratification with the AUC. We have had this occasion with a number of countries. They ratify, it takes close to 2 years before they deposit the instrument of ratification. Follow that up. We have this number of countries, they ratify that the instrument of ratification is deposited. I thank you.
Okay. Lucia, did you want to say something before we transition? I see Maria Lucia.
Thank you, Chidi. I just wanted to call on the attention of the legal counsel. You know, Angolan NGO started to participate at the African Commission in 2006. And we didn't have even translation into Portuguese. If you could not understand English, it was not useful for you to participate. For the documents, we want to see where are the Portuguese version of the documents, because we are translating the documents, even for the government. Sometimes we are the ones who have to provide them with the documents in Portuguese. So if the African Union is translating the document, they have to make sure that people that need them have access to them, not just translate it. How many are they translating? How can we assess it? Because we participate at the African Commission sessions, and most of the time we only see the version in English, French, and Arabic. And all of you participate at the African Commission, and you know that it's always a struggle for the Lusophone to have access to the documents, and that makes it very difficult for them to participate, to assess the process, because most of us speak Portuguese, we do not speak English. And it's been an habit of the English speaker to think that we speak English, and we do try, we make some effort, but the documents are not there, or at least she should tell us where to get the documents.
Okay.
Thank you.
That's clearly, because this is all part of the package of access issues that we've got to address. And as I do that, as I try to hand over to Don, can I just apologize to all of those who have not been able to get questions in. I see we've got very profound participation here from all over the world. I see Adobe Boka from the United States. That must be an early waker. Ikechukwu is from Berlin, I suspect. Attila can only be from Hungary. Professor Rachel Murray joined us from the United Kingdom, and I see our friends from Kenya. Zimbabwe, of course, is from Zimbabwe. But the participation here has been really fantastic. And Dr. Horace Ajalon from Arusha as well. Efia from Dakar. Alpha Sisse woke up very early from Washington, D.C. To all the colleagues who have joined us from everywhere, thank you very much. And to the Secretariat of the coalition as well, thank you for making this possible. This is just, I suspect, the first in a series of conversations that we are hoping to have with the relevant institutions. But Don, who at the moment sits at the chair of the board of the coalition, can tell us what's going to happen next. And with that, can I turn this over to Don, please? Thank you very much. Can you unmute?
Yes, I've unmuted now. First and foremost, and most important, I'd like to say thank you very much to all of our participants for joining us today, all of our fellow colleagues. At the moment, there's 66 of us left. When we started, I think we were closer to 90. I know there are many other lovely things that you could be doing on a sunny Friday afternoon or morning or evening, depending on where you are. So thank you for joining us. I also like to thank very much our coordinator, Sophia Ebi at the Secretariat, and her colleagues, our administrator, Rebecca Nyange, and the ICT intern that's helping them, who has also helped us here, Adam Chatba. Especially for Sophia and Rebecca, I'd like to thank you very much for keeping the flag of the African Court Coalition flying despite the challenges. Also for organizing this webinar. I hope it doesn't embarrass you if I tell the members present that Sophia and Rebecca have worked for several months without pay, you know, just to keep the coalition alive, keep some basic activities going, interface with the court, arrange these webinars, and they actually have a range of other activities in their work plan. As we know, on the continent, resources, especially for civic activity and for civil society, is a challenge. At the continental level and continental level CSOs, the last 4 years have been very, very bleak. Many organizations have folded over. Some we've put into hibernation, and we will consider what to do with them later. So for SCC to even be a bit alive, not just the board, it's also really what our colleagues have done. Having this conversation makes us know that there are many other conversations we need to be having. This one is specific on the court, luckily we're very lively. Around the work we need to do in Addis, in Midrand, with the AU organs and institutions based there, we've not been doing so well. And part of it, and only part, but a big part has been the resources. So we really thank those colleagues that sacrifice to keep us alive. Maybe COVID-19 can be an opportunity and not just a challenge. As we move a lot of things online and into online collaborative working, it also behooves us as citizens and as CSOs to reorganize our advocacy and see how we can reorganize our human resources, our technical resources, our technological resources, the limited financial resources, and any other resources so that we can keep activism alive. As you know, COVID-19 has been very good for dictators and despots in Africa as well as elsewhere to really stop the participation of citizens in their governance. In that regard, I'd like to thank the Open Society Foundation's family, who have also assisted us in convening this webinar and in paying for some of the facilities that needed to be paid for, such as the simultaneous interpretation, the professional rapporteuring, and so on. OSF especially for those of us who work at the regional and the continental level in our continent, OSF is one of the very few partners that has remained with us despite the challenge. I'd like to personally thank Professor Chidi Odinkalu and Mr. Ibrahim Khan. I don't know if I've heard Ibrahima's voice during the session at all, but I know he's there. Those of you may remember or may know, have a very intimate history with the African Court Coalition. They actually started it for us. And that's going to 16, 17 years ago now. They also single-handedly worked to get us the last raft of ratifications to reach 15 so that this system could kick off as it did in 2004. So a special thank you for helping us convene this, for moderating it, for financing it, and also for still remembering ACC. I'd like to thank the East Africa Law Society, which has agreed since last year to host the Secretariat of the Coalition for free. Even though, of course, for the last few months, we are all still working from home, but we have an institutional and physical address donated to us by one of our members. So I'd like to thank also the members of the Executive Committee, especially those present in the call, Avocats Sans Frontières, Dakar, Senegal chapter, Yare Fall, who spoke earlier, the East Africa Law Society, Tanganyika Law Society, PALU, and in that I'm not thanking myself, I'm thanking my colleagues who also do a lot of the work in the background. The Southern African Litigation Center, Kajal, my sister kicked us off when we started, the Zimbabwe Lawyers for Human Rights. On the point raised by Lucia, and I thank you very much, Lucia, also for raising it, on Portuguese and also Arabic. I think you raised a larger point, not just what the member states can do, the AU can do, the regional economic communities can do, but also how much we citizens try to be inclusive, to make sure that when we organize things like this, despite limited resources, we try to include the major languages of the continent, all of them. When we make publications, when we do advocacy. As you may recall, from your time in the past, the African Court Coalition at least used to do that, and would bring the publications in English, French, Portuguese, Arabic, and even Swahili. Part of the work plan is to update some of our publications and reprint them in the next few months, and we'll make sure that is done. I also thank Professor Nyungeko for joining us and for giving us those insights. We learn all the time. Thank you for finding time to join us, especially knowing that it's in a different time zone for you at the moment. I'd like to thank my sister, Ambassador Dr. Namira Negem. One, for joining us. Two, for having the most beautiful background, even though you're in Cairo, to your call. And three, also for the points that you made. As you can see, maybe for reasons beyond their control, our colleagues from the member states who had confirmed earlier were not able to join us, but I'm glad that you still did and found time to share some of your perspectives. And also the comment that you've made that you're willing for us to continue conversing. It's not an easy time for anyone, certainly not for you in the seat that you sit. I know that very well. But I hope you take with both arms a challenge given to you by Chidi, and we see what more a robust Office of the Legal Counsel can do to protect the integrity of the African human rights system that's under attack, not just in this case in terms of some delegitimation that comes from withdrawing Article 34 declarations, but also some of the dialogue we've seen the member states make and some organs of the AU make with regard to other parts of the system, the Banjul Commission and so on. We offer you a hand of partnership in that, and we'll try to be very strong. I also thank Dr. Robert Wunde Eno for joining us, taking the time to join us. I would have you know, colleagues, that there was actually a virtual session of the court that started at 1 and was to run until 3, and I think ran a bit longer than 3. And Robert actually sacrificed that session and delegated it so that he could participate actively with us. We do wish that the internet around his part of town would have been better to him and to us, but his resilience ensured that we still were able to engage and have a back and forth and interactive dialogue. A lot of issues have been raised, and I do not intend to summarize or to respond to all of them now, just touch on 3 very key points, 3 few points. One on advisory opinions. Some people have suggested that we should invoke more the advisory jurisdiction of the court in these times and generally, and agree to that. A lot of the issues that we want from the court is to set out the law clearly, whether it is in a case involving a single country or not. But once the precedent has been set or the exposition of the law has been given, it applies to all the states parties of the protocol, and in certain regards applies to all the member states. In any case, all the member states, I believe, except Morocco only, are parties to the African Charter on Human and People's Rights, and many of them are parties to its protocols, the Protocol on the Court, and very, very importantly, the Maputo Protocol on the rights of women in Africa. The challenge with the advisory opinion jurisdiction of the court is that under the current interpretation of the court as to who has locus standi to file such a request, it has limited to African organizations recognized by the African Union, meaning recognized by Addis Ababa. So the fact that you might have recognition, observer status with other organs and institutions or institutions of the AU, the Banjul Commission, the Child Rights Committee, the Pan-African Parliament, and so on, does not guarantee you. At our last check, there's probably only 3 organizations that have that kind of formal observer status with the AU Commission, with the AU, or that have a formal memorandum of understanding with the AU. And that is PALU, the Pan-African Lawyers Union, the Global Pan-African Movement, if I remember correctly, and the Pan-African Women's Organization. And unfortunately, at the moment, none of those 2, as far as I know, have a litigation or even legal unit. So practically, at the moment, the 1 billion people of Africa from the 55 countries are left with only one organization that can channel their requests for advisory opinions. That is regrettable in several regards. I think it should be another whole debate altogether, how we open up the field on having observer status or MOUs with the AU. It should be another discussion altogether that we should have with the court on how it should reinterpret organization recognized by the AU to be more reflective of the diversity and the dynamism of African people and their chosen institutions. But for now, that is what we're left with. At the moment, we have 2 such advisory opinion requests pending. One on decriminalization of petty offenses, which we filed in coalition with a number of sister organizations that we operate with, about 6. We filed that in 2017. We think the opinion would come out anytime soon, probably delayed by COVID-19. And together with Chidi and Ibrahima, PALU filed another request early last month on COVID-19 and elections. And Chidi, if you'd like to speak about that for a minute after I finish, that would be welcome. And we're hoping that the court would give guidance to the member states, to AU organs and institutions, and to citizens on what to do with the elections that we had scheduled in the context of, in the era where we're still having COVID-19. Do we go ahead with them? And if so, what are the guidelines? Do we postpone them? And if so, what are the guidelines? When states are unable to facilitate a proper discussion with their citizens, not just with the political parties, what should be the guidelines under the law of the AU? We hope to do a bit more, but I said there's a challenge there for the court itself, and there's a challenge for other AU organs and institutions, especially the Office of the Legal Counsel. The point has also been made that the Commission should look into ways of having a more consistent, more prolific pipeload of cases coming from Banjul to Arusha, to the court. Again, I hope that's a challenge the court welcomes, the Commission welcomes with both arms. I have some very colorful views around how the court and the Commission have managed their complementary relationship over the last 14 years. Very colorful for both. I will avoid that today. But the point to be made is that the Commission can get a lot of help, even with the minimal human resources at its disposal. It can refer cases, and I believe there are enough African institutions, law firms, law schools, law clinics, NGOs that can assist the court, the commission, to prosecute its cases pro bono at the court. Currently, Commissioner Bahame, Tom Nyanduga, and Palu are doing that with regard to the only existing referral at the moment from the commission to the court, the Ogie Commission case. The Ogie case was referred in 2012. From 2012, there's been no referral. As I said, let me not say any more. I apologize in advance on behalf of Commissioner Dr. Solomon Ayele Daso, who also didn't join us. As you may have known, in the citizen dialogues we've been having over the last 2-3 months, one of the most consistent to come on the table anytime civil society calls has been Dr. Daso. But as you recall, as you may know, Addis Ababa and Ethiopia are undergoing some very difficult challenges this week and last week. So we pray for them, to whoever each of us prays for. A minute's, silence, thought, and prayer for them. And we hope they pull out of it. And we need to see, as Africans, what kind of solidarity we can offer to them in the colleagues. My biggest challenge is to the member states. And I challenge us. A lot of the recommendations we have made are like, how do we work with the court to engage the member states? Which is well and good. But how do we more robustly as citizens hold the member states by their shirts and tell them that these are obligations that they owe us and not favors that they're doing for us? Perhaps that in itself should be the subject of a separate conversation, how we will more robustly hold the states to account. Because the things they're doing is not because of ignorance, it's because of mischief and malice. And times are hard, but it's probably doable, especially if we help each other. Let me stop there. Chidi, if you want to speak a minute or two more about the COVID-19, I request you can. But otherwise, I think we've taken a lot of the time of our people, and we just thank you, and we assure you there'll be a written report in the various languages of these meetings, and there will be a pipeline of other webinars organized under the umbrella of the African Court Coalition. Thank you. And on that regard, for any members present who have not paid their subscriptions, please think of Sophia, please think of Rebecca, send them something, let them at least have a quarter of a salary for this month. Thank you, everyone.
Thank you, Don. I think we've taken enough time. I'm not sure it's possible to dwell on the advisory opinion. You've, I think, captured it. A lot of us know that there are lots of elections that have been deferred in different countries or going through different challenges across our countries because of COVID-19. From Ethiopia, where there is a legitimacy gap for government after its tenure expires without an election, to places like Senegal or Cameroon or Nigeria or South Africa, where specific elections have been postponed. And the advisory opinion essentially calls on the African courts to offer African countries an elucidation of the applicable legal standards to govern elections that take place which are affected by COVID-19. There are about 21 such elections this year, about 13 next year. And the estimation is that COVID-19 is going to continue to have an impact on African elections into 2022. So that advisory opinion, I think for many countries, will be vital in shaping the rights to participation and democracy across our continent. And as I round off, can I please get tribal here and acknowledge, because otherwise I may be in trouble for reasons you will understand now. My personal lawyer, Ms. Gloria Ballason, who has joined us here and whose work continues, whose litigation skills continue to keep me out of prison in my home country. If I don't acknowledge her, I'll probably end up in prison. But thank you very much, everybody, for joining us on this. And please look out for both the recording and report on this, as well as invites to the next meeting by the coalition. Thank you and have a wonderful weekend.
Yes, thank you everyone and goodbye.
Thank you. Bye.